Good morning. I'm Mason County Judge Executive Owen McNeil. I want to welcome everyone to the February 17th special call meeting for the Mason County Fiscal Court. We are in order. Please rise and join me for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning. Good morning.
Morning, Judge.
Morning, everybody. Okay. The Projects Director Muse, can you start us off with a roll call first, and then we're going to circle back.
Thank you.
Commissioner McKay?
Yes, ma'am.
Commissioner O'Hearn?
Yes, ma'am.
Commissioner Frame?
Yes, ma'am.
Judge McNeil?
Yes, ma'am. Commissioners, I need a motion for Project Director Kim Muse to serve as the clerk for this special call meeting February 17th, 2026.
Excuse me.
Oh,
As I understand, Stephanie, the county clerk's not available next Tuesday either.
Correct.
You can go ahead and make a motion to appoint her clerk for both meetings and save doing
yeah.
next week. So moved.
Second.
we have a motion. We have a second. Any additional discussion? Roll call, Madam Clerk.
Commissioner McKay?
Yes, ma'am.
Commissioner O'Hearn?
Yes, ma'am.
Commissioner Frame?
Yes, ma'am.
Judge McNeil?
Yes, ma'am. Commissioners, that brings us to old business, which is ordinance number 26-01, consideration of a text amendment for data centers for the first reading. In front of you, you will see 8-inch bound binder, as well as 2 letters that County Attorney Estel and our administrative team have bound for you, and I'll turn it over to County Attorney Estel.
Your Honor, I have not circulated to each other. Everybody in the crowd's probably aware of from public meetings and these meetings, but Hank Grady is here as counsel for we are Mason County and would be representing opponents to this project today. Tanner Nichols of Frost Brown Todd on behalf of the data center prospect. I invited both of them, as you're aware from last meeting, to file comments. Tanner did so in form of a red line proposed draft, which I have in your record just written his name on the top of. Mr. Grady's is in form of a letter. I did not exchange them with each other or anybody else, and they're laying on your tables before you. So I'm going to file those. I've given them to the clerk pro tem, and we will have those filed with the minutes of the meeting. Obviously, if you want each other's after this meeting, they're public record, and you're welcome to them. That'd be the first item, Your Honor. Second of all, and we discussed this at last meeting, it has been consistent in the way the Mason Fiscal Court has conducted business, and typical of most legislative bodies who have planning commissions, to adopt the record of the planning commission as the record in this action, as opposed to opening up public hearings. As I said, we've consistently done that under the cases of, and I won't do the citations, but 2 cases, City of Louisville versus McDonald and Residential Development Corporation versus Campbell County. It's my recommendation that you adopt the entire record of the JPC. Mr. Larger, and George did stick his head out so I could see he was here. So if you need him, he's there in the corner, but Mr. Larger has signed a certification that this is the entirety of the record from the Mason County Joint Planning Commission, and it'd be my recommendation that you decline to take additional evidence and adopt the record of the Joint Planning Commission before you as the record to be considered in this matter.
So moved. As presented.
So we have a motion.
And I'll second that.
We have a second to take in the information from the JPC. First and foremost, before we vote, I want to say thank you to our unpaid volunteers, citizen members, Joint Planning Commission, as well as Mr. Larger and his team who worked for several meetings, getting that compiled, getting that done, but also highlight our admin staff here, Miss Sherry and Miss Shannon, Projects Director Ken Hughes and others for pulling all this information together. Now, we have a motion and we have a second. Is there any additional discussion?
It's very organized, and Sherry did a great job putting it together, so I appreciate that.
Agreed. Roll call, Madam Clerk.
Commissioner McKay?
Yes, ma'am.
Commissioner O'Hearn?
Yes, ma'am.
Commissioner Frame?
Yes, ma'am.
Judge McNeil?
Yes, ma'am.
And the only thing I'd say at this point, Your Honor, is that that means that you are to consider only matters in the record. We've determined that there will be argument-style hearings, so there's some leeway in argument or summation. If either of them got into matters outside or tried to introduce new studies, that wouldn't be permitted. So I guess I'm your objector if something like that happens. But we don't contemplate that. But I think we're ready for, unless you have some other matter, ready for the argument. And I emailed both counsel, and Mr. Nichols said Mr. Grady could choose. Is that what you said?
Yes,
Yes, sir.
So Mr. Grady, you can go first or last.
I chose first.
Okay. If you'll come up and join us here at the podium, Mr. Grady, we appreciate your interest and appreciate your attendance.
And I don't recall, you didn't reply specifically if you were sharing time, but if you're sharing time, you'll be responsible for managing the 30 minutes. And I'll start a timer when you're starting.
May I distribute my letter to the members? I've included a couple of pages from the record, and I'll show them to you.
Sure.
But I'd like to give this
That's
copy to the members.
That's fine, and I won't start my clock until 1 o'clock.
I need it.
He's added a little bit to it.
Mr. Grady, do you want to sign at some point or 2 minutes out or something?
I had not indicated I wanted rebuttal before, but I would like you to stop me at 5 minutes. And I believe I have 30 minutes. Is that correct?
Yes, sir.
That's for you to make the rules that.
And so I would like to stop it.
That's up to you. That'd be your discretion.
Yes, sir.
You
Give me
have to-
a warning when I'm getting close to
So at
5
about
minutes.
23 minutes, I'll give you a hands up, okay?
And then leave 5 minutes.
We'll stop you at 25 and leave you 5 minutes.
Good morning.
Good morning, sir.
My name is Hank Grady. It was a beautiful drive this morning from Midway to Maysville as the sun was coming up, and it's good to be here. I'm Hank Grady. I'm an attorney from Woodford County. My office is in Versailles, Kentucky, and I've written a letter to you. This is my second letter to the Fiscal Court. I was with you on September 9th. I wrote a letter asking that you consider adopting a zoning ordinance to address data centers. Mr. Esther referred to me as the opponent. I'm here today in support of a zoning ordinance that protects the community of Mason County and prepares you for data centers. So it's not exactly the case that I am against being here. I'm in fact in favor of being here to help adopt an adequately protective ordinance. I asked for that in September, and you all were a step ahead of me. You all adopted a resolution that day to begin the process that brings us here. I was before you early last week on the 10th, where the ground rules were announced, and I'm here today to make a presentation regarding what is in front of you. In general, my concerns this morning are very similar to my concerns in December when I spoke to the Planning Commission. I delivered a PowerPoint presentation, I referenced several resource materials, and I submitted a letter and I submitted comments. So I have begun my letter to you today with the same beginning that I submitted to the Planning Commission on what I believe are the most serious failings of what's in front of you. You will see as I go through my letter, I use two terms, and I want to give you the overview. In some places I say, I request that you remand. As I request that you recognize that what the Planning Commission has sent you is inadequate, and it should be sent back to the Planning Commission so that the Planning Commission does a better job of addressing the matters that need to be addressed in an adequate ordinance for Mason County and Maysville. In other places, I use the word add or address. So in some situations, I believe my suggestion is simple enough, what the content I've given you is clear enough that you could simply say, we will adopt this language in the ordinance as a step-by-step process. But I will be asking you today and next week to go through these specific objections and address these omissions. But because I believe the ordinance is sufficiently defective currently, the overall request is that you send this back to the Planning Commission and address the issues that they have failed to address in the draft that they have sent to you. Today, like December 9th, the most serious problem with that draft and today's final draft is that it does not adequately protect the citizens' right to participate in the data center site selection process. The text that you have would allow a proposed data center in land currently zoned I3, rural industrial, simply by preparing a development plan. What that means is that the Planning Commission could approve the development plan, and your ordinance, as it's currently written, does not require a public hearing, which means the public would get no opportunity to speak on a data center at all under the current version that you have, if they propose to put it in an I3 zone. Kentucky law actually backs that up. A development plan is not required to have a public hearing unless there is text in your ordinance that requires a public hearing on a development plan. Even when a development plan must get Planning Commission approval, there is no requirement in the law up to now, and none in your ordinance, that requires the Planning Commission hold a public hearing. So the first step is to amend the ordinance so that the public actually can participate in the decision about whether there's going to be a data center anywhere in the county. Now, obviously, if they need to rezone, there's a rezoning hearing, all right? But I'm talking about the ordinance as it's currently written, and it allows a data center in your I3 simply by preparing a development. Now, the development plan has lots of details. Some of them I think are positive. I'll get to those. But right now, it does not allow any public participation. This is a glaring omission on something as important as a data center. As you will see when I get through my letter, I'm asking that every data center, whether it's in an I3 zone, every data center should be zoned to a specific zoning designation that doesn't yet exist in your ordinance for data centers, and that it be a conditional use. This was in my suggestion to the Planning Commission. All of that has been left out of the text that is in front of you. That I consider is the most glaring omission of the document that's in front of you. A second serious problem with the proposed text is that it contains nothing that protects Mason County's prime farmland and farmland of statewide importance, which is clearly contrary to the text found in your 2016 comprehensive plan and your 2025 Mason County comprehensive plan update. Without any language that protects prime farmland and important Mason County farmland, this proposed text validates the fears of my clients that this process of adopting a zoning ordinance is a step toward removing as much as 8,000 acres of farmland from farming. This is not in Mason County's public interest. This is not in the interest of Kentucky. We must protect our prime farmland, whether it's Woodford County farmland or Mason County farmland or in between. Based on the foregoing, we recommended the following addition to the Mason County Data Center Ordinance to the Planning Commission, and we therefore recommend it to you. So if you'll turn to page 3, Section 4, General Requirements Relating to Location of Data Centers. No data center shall be located, number 1, on lands with slopes over 20%. You can read the rest. Number 2, within a 100-year floodplain unless flood impacts are mitigated. 3, on wetlands. Number 4, on prime farmland or farmland of state importance. Or number 5, where such facilities may cause or contribute to the taking of threatened or endangered species. So the first requirement is to add language that protects prime farmland and farmland of statewide importance, or the second requirement. The first is to bring the public into the process. The second is to fix the ordinance so it protects prime farmland. Number 3, and this is to the Planning Commission and to you. We asked the Planning Commission and now we ask the Fiscal Court to strengthen the setback requirements. I attached in the record, you'll see Oldham County the Planning Commission has recommended 1,000-foot setbacks from residential zone to residential use properties. I've also attached in the text that's in front of you, language from Frederick, Maryland, with a 500-foot setback. Based on the foregoing, we recommended the following changes. We recommended to the Planning Commission, and we now recommend it to you. Data centers, I'm under setbacks. I won't read all the text. At least 500 feet from all outer perimeter property lines, at least 1,500 feet from a sensitive use or boundary of any residential, commercial, or agricultural district. Those are recommendations we made to the Planning Commission. We're making them this morning to you all. Specific comments to the February 4th, 2026 final draft. I'm no longer reading from the letter that I submitted to the Planning Commission. I'm reading for what is directly in front of you, including the findings of fact. I'm now at the bottom of page 3. The Planning Commission findings of fact and conditional use adopted February 4th on a 5-to-1 vote fails to comply with KRS 100 in general and KRS 100-213 in particular, where these proposed text amendments are not in agreement with the current comprehensive plan and do not recite either of the statutory exceptions when a zoning change is proposed that does not agree with the comprehensive plan. The language found in conclusion of law number 2, and I'm quoting from the findings the Planning Commission made, quote, empowered to enact land use regulations in conjunction with the comprehensive plan. That is not the criteria of KRS 100-213. Nowhere is a zoning amendment approvable if you say it's in conjunction with the comprehensive plan. The zone change is to be in agreement with the comprehensive plan, not in conjunction with the comprehensive plan. The zoning text amendment must comply with KRS 100-213. This proposed amendment does not. Max Moran, speaking for Weir Mason County, spoke to the Joint Planning Commission on September 3rd, 2025, and he provided them with text to amend the comprehensive plan to specifically address data centers. The Planning Commission failed to take action as part of the comprehensive plan process. Last week, Judge McNeil stated that he has been working on this project for 2 years. Judge McNeil has been on the comprehensive plan update committee. From my perspective, there is no justification for the current failure of the comprehensive plan to plan for and address data centers in Mason County. I believe it is a violation of KRS 100 for the Mason County Fiscal Court to seek to enact a data center ordinance text amendment prior to amending the comprehensive plan to address data centers in Mason County. Where the current comprehensive plan has policies that expressly provide for the protection of prime farmland or statewide important farmland, this proposed ordinance, which ignores that consideration, violates what is in the plan. So it is defective because it is addressing something that is not addressed in the plan, and the plan should address where data centers should go, and it doesn't. And what you have in front of you fails to address what is in the comprehensive plan, and that is this community protecting its prime farmland. In paragraph 8, I have other quotes from the comprehensive plan, including the quote on page 94, random development in Mason County has a negative effect on farming. Comprehensive plan, page 94. The proposed final draft fails to mention, much less protect and retain prime farmland and farmland of importance. It's not in agreement with the comprehensive plan. We support on page 1 of the final text the addition of the definition of sensitive use. That is an addition that wasn't in the draft we looked at in December, and that is a positive. The fiscal court is requested to disapprove section 2 of the permitted zoning districts as written and remand this section back to the Joint Planning Commission to establish a new zoning district, industrial data center, and add the following language or language equivalent. Data centers shall only be located in the heavy industrial zoning district I2 or the rural industrial zoning district I3 as a conditional use upon 1, application for a map amendment to reclassify the property on which the data center will be located to industrial data center. That is a new zoning designation that does not yet exist in your zoning ordinance. The Planning Commission should be instructed to create that new zoning district, and upon the issuance of a conditional use permit by the Commission or the fiscal court in conjunction with the requested zone change. If the members of the fiscal court and Judge McNeil will turn to the pages at the back of my letter, there's 3 pages I want to call to your attention right now that were not in the letter that I sent to Mr. Estel on Friday, but these were in my presentation to the Planning Commission, and they're in the record in the 8-inch binder in front of you. I got to go through the binder, but I would like you to look at these 3 pages. The first page is from a study by a well-respected, relatively neutral planning organization on regulating data centers. And you'll see that they describe 4 options. Option 1, create an overlay district. Option 2, create a planned innovative research and technology district, PIRT. Option 3, note preferred data center locations in the comprehensive plan and invite owner or hyper initiated rezoning applications. And option 4, implement a specific data center zoning district defined by the ordinance. The 2 that I think are probably the most widely used in the communities that are furthest advanced in this are an overlay district or a special zoning designation. I think an overlay district is an option worth considering. I'm recommending that you create a specific data center zone, not that you, I'm recommending that you ask the Planning Commission to propose a specific data center zoning district for your adoption in addition to the zoning ordinance of Mason County and Maysville. Below that are 2 pages, and at this point I need to remind myself, it's my belief that even though you've got 8 inches of documents in front of you, I attempted to put in my testimony for the Planning Commission a number of documents, and I encountered a rule from the Planning Commission that said I was not allowed to put in documents longer than 10 pages. And I asked to have that rule waived. I wanted to introduce the Kentucky Resource Council Model Data Center Ordinance, which I cite throughout this document. It's 20 pages long. I wanted to bring in the study that the page you just looked at came from. It's 60 pages long. And I wanted to introduce a study from Prince George County in Virginia, which is 400 pages long. My understanding is that a few of my requests were granted, but I'm pretty sure that the Planning Commission refused to allow the 400-page document into the record. I do need to make sure the record reflects my objection. I don't believe that the 10-page requirement is fair. It inhibits my ability to provide the complete document that I'm quoting from. And so I believe that I have been unfairly limited in my presentation by that, what I believe is an arbitrary rule, and I want the record to reflect that. But the part of this document I'm calling to your attention are these pages where this study, this is a community, Prince George County, Maryland, that was going through what you all are going through. They were studying how do we best plan for data centers. It took them a year to do it. They prepared a 480-page study and they looked at 6 communities: Loudoun County, Virginia, quote, the pioneer; Frederick, Maryland, the reclaimer; Fulton County, Georgia, Atlanta; Franklin County, New Albany, the deal maker; and Fairfax County, Virginia. Franklin County is important because your consultant cited Franklin County, the consultant that the county hired for the Planning Commission. He quoted extensively from the rules in New Albany, Ohio. And as you can see there, that is the least restrictive zoning ordinance of the group. New Albany is clearly an outlier. While land use talks about the positives in New Albany, but basically it is the least protective of these 6 that Prince George County was looking at. The next page is another summary of each of these, but you'll see that Frederick, Maryland is the one that includes protecting agricultural lands. Some of these use overlays, some of these use special use zoning designations. I've already mentioned that. I think that's an interesting choice. I don't have a dog in that fight. Either way, I'm recommending a special data center zoning district. But this is to give you an example of another community going through the same process you're going through, but doing a more systematic study of what is state-of-the-art management, preparing a community for data centers. And I would ask you to use those examples for your own information, and ask the Planning Commission to give you something more comprehensive. How am I doing, Ms. Vestal?
You've got 9 minutes left on the total.
I'm now on page 5. I've already mentioned setbacks. You'll see in paragraph 12, I talk about, here's, I'm sorry, let me the section on paragraph 12 refers to the setbacks that are in the proposed ordinance. And what you have, 500 feet, is an improvement on the smaller setbacks in earlier drafts. I would ask the fiscal court to either add or to ask the planning commission to add back the larger setbacks for sensitive uses. That was in an earlier draft. It has been taken out, and I would recommend that it be brought back in, and where there are sensitive uses, the setback be 1,500 feet. Secondly, an earlier draft had language that allowed greater setbacks where necessary to help meet noise requirements. And that sentence has been deleted in this section. Yeah, I would urge you to ask the planning commission to reconsider that and perhaps bring back the opportunity to set a more stringent setback requirement if it's necessary to meet noise requirements. In paragraph 13, I quote from page 3 under section E, buffering and screening. And it talks about, this section describes an affirmative and continuing duty. And this relates to maintaining the screening. But it's talking about something into the future that needs to be maintained and continues. And then later on page 4 and 5, there's some other requirements under noise that talk about into the future, a post-construction noise analysis and monitoring enforcement to make sure the noise centers are staying within their limits. Those kinds of future activities are precisely what a conditional use addresses. That's how we have conditional uses, to be able to make sure the planning commission has authority to monitor into the future and make sure that the requirement that the applicant said he's going to comply with can be held accountable. And without conditional uses, the planning commission has no regular mechanism to enforce these promises into the future. And the consultant that spoke to the planning commission, he referenced data center ordinances in Ohio, and those included situations where conditional uses were required. I'm not going to go into that detail here, but there's plenty of example of conditional uses as part of data center government across the country, and it's not here, but it needs to be here. And so I would ask that you send this back and to create a zoning designation for data centers and require conditional use.
You're at 5 minutes.
1 minute wind up,
1 minute?
and then we'll reserve your 5.
I thought I had 9 minutes a minute ago. That was a very quick 9 minutes.
No, 9 minutes on the total. That's,
9 minutes on the
if
total.
you'll wind up, then we'll reserve your 5.
Let me use 1 minute. Number 14, I've got language there that urges you to use that lighting section. The lighting section, I believe, is inadequate. Page 6, there are a number of other specific suggestions. I would urge you to read those, and I would recommend them. There are different standards for noise and 2 different measurements for noise, dBA and dBc. And I'm urging a 40 dBA, 45 dBA, but you'll see those. And then skipping down to page 7, I do come back to, I do want to mention the community benefit agreement. Mr. Shell, the consultant from Kimley Horn, talked about the Ohio plans. New Albany, this is under the community benefit analysis, which is part of your plan. I'm urging the community impact analysis include a community benefit agreement, which is actually requires a developer to sign a document that he will actually do what he says he's going to do. And this is in the text that Andy Shell was recommending you all consider.
Mr. Grady, if you want to keep your 5 minutes, you need to wind up.
I'll keep 4 minutes.
Okay?
Okay.
Well, you're
Finally,
there.
members of the fiscal court, I do at 23 ask that you require the assessment, the environmental assessment, assess the impact on farmland and on chemicals in the cooling water. And finally, section Q seeks, in my opinion, to penalize a citizen who does not get adequate resolution by requiring a $500 arbitration fee. We believe this penalty is an unconstitutional penalty and cannot be justified in KRS 100. And we believe it's an insult to the people that live and work in Mason County. We ask that you remove the penalty and that you remand all of this back to the Planning Commission to address the concerns that I've put in front of you. Thank you.
Mr. Grady?
Mr. Grady, do you remember where this graphic is from?
What did you
The
say?
first one, the first graphic? Regulating data centers, do you remember where that's from?
I do. If you'll let me get in my briefcase, I can.
Just let me know in a minute. Yeah, sure. Okay.
I'll take care of that in my 4 minutes.
Okay,
Okay.
perfect. Thank you. Good morning.
Good morning.
Good morning. Thank you.
Thank you, Mr. Grady. I'm not going to need 30 minutes or 25 minutes, I don't think, so, but keep it timing, and I'll try to respond to a couple of Mr. Grady's comments too, and may be helpful to you all. So good morning, my name is Tanner Nichols. I'm an attorney at FPT Gibbons, a law firm that's representing a potential developer here in Mason County. Most of you have likely seen me at the other meetings, and I spoke at the December 9th public hearing of the Joint Planning Commission that they held at the community college. And so I recognize a lot of the faces here. Thank you for the opportunity to speak again this morning. First of all, I want to say thanks to the JPC and George and their effort and all that they've done. As the judge pointed out, they're unpaid volunteers, and it's amazing work that they do. They really dug in and studied the process. The JPC visited site locations, looked at other communities' work. They looked at the other communities' regulations and have been able to present you all a robust recommendation. I can see the binder, right? It's a big binder of stuff that they looked at and put together. And that's why we're here today. I also want to say that Mason County is a pretty amazing place. I'd never been to Maysville and Mason County prior to my visits, and so when they talk about up on the hill or then down on the river, I know what that means now, certainly. But obviously Mason County is much more than the JPC and the fiscal court and the judge. It's the people, right? It's the schools, the churches, the businesses, and all the things that make Mason County great. And that's why my client wants to plant roots here. I've worked all over the state of Kentucky, and I can tell you that this place has been welcoming. I've had conversations with my wife and family, and Jack from Stantec. He works all over the country for data center developers, and he said, this place, they treat you better. And so what I would say is, although people in this room disagree, they're not disagreeable. So, and I thank you all for that and how you've treated me. And I also want to remind everybody here that this is the first part of the process. We're doing the text amendment here. There's still going to be, if my client wants to come here and put in a data center, we are going to have to go through a map amendment process. So we're just putting in the rules in place for, and I think most of the people here, and I heard a lady come up and said, I'm not against data centers. And I think most of the citizens here would agree that zoning and local regulations should not be designed to stop progress or development, but to put the rules in place for orderly plan development for local communities. And so the word that I use is guardrails. And so that's what we're trying to do. Zoning in many ways is a political process, right? You get input from the community, but ultimately elected officials have to make decisions. And these officials have to weigh the arguments that the change will come with future development. So some people will say, these are bad things. And then other side will say, but listen, we get all this other stuff with it. And you all have to weigh those. I think it's safe to say that not everybody's going to be happy, right, with the results today or possible results of future development. The county and county officials have to weigh the impact of future development with the benefits to the community at large. In a vacuum, I don't think anyone would disagree that selling real estate for prices that they would have never expected to get is a bad thing for those families, those potential sellers. It could be a life-changing windfall to some of these families. I've heard at other public meetings, people would get up at the public meeting out at the community college and say, well, we're not opposed to those people selling, we don't blame them. And so we don't think that's a bad thing. We don't know the situation of every family. This money of selling their potential farms, that could bring generational change to those families. Would it be a bad thing if we had a couple of thousand construction jobs for the county? I don't think so, right? I think most of you agree that would be a good thing. What about infrastructure improvements? What if the county had money to invest in water treatment or roads and sewers? I think most people would say, in a vacuum, that's a good thing. Increased tax revenues for the schools or public safety and roads. What about 100 new tech jobs, permanent tech jobs for local citizens? For young people could get those jobs and they wouldn't have to drive to Cincinnati or Lexington. I think all of these are obviously good things that have to be weighed by public officials. Now we have to look at the language. So you all have a red line of what my client thinks of the text amendment and the changes that we want. I've heard several comments at the JPC that they said that the text amendment needs to be best in class. And I certainly understand that sentiment. But let's look more closely at the practical steps and effect of that seemingly simple, appropriate language of best in class. When George or any of the county officials, the county planning officials at any other location, when they start drafting new text amendments, where's the first place they go? Probably if they're like me, right, they go to Google and they type in data text amendments and they start looking at other counties and they go online and review the language from other jurisdictions. That's what I did. It's probably what you all have done too. He likely reviewed text amendments from across the country, but he looked at urban areas. He looked at places where they treat all industrial development the same. They may not necessarily say, oh, data centers have to do this, but a power plant has to do this, or an industrial manufacturing plant has to do this. They say if it's in this, they have a list of uses, and if it's in that zone, it's allowed, and they all follow the same rules. But here's also something important. He probably pulled it when Mr. Grady talked about Frederick, the DC area, and those particular, they had this big giant report. Likely, I don't know, but likely that had a big staff. It wasn't one person. George is a staff of one for the whole county at Mason County. And so, it may have a planning staff of 50 people. So you're looking at an ordinance and looking at studies that has a huge staff. So he may have taken a piece from Ohio or Washington, D.C., or Arizona or Colorado, and then he puts those all together. While we think this proposal is a good start, in my experience, there are a few items that need to be reviewed more closely to understand the impact on development. Because there can be explicit moratoriums. So some counties can just say, we don't want data centers at all. But in other places and other uses, you can end up with a moratorium but not be explicit about it. If your rules either are so strict or the setbacks are so big, you put developers in a situation where they can't, essentially you are putting a moratorium on the development. And the other thing that you have to consider is sometimes when we always say developers just need to know the rules, but then there are times when you put stuff in the rulemaking that it's too risky for a developer to come out. because they can't plan for the outcome. So if they say, give a report, but the city or the county has never reviewed a report like that, then we don't know how the city or the county is going to react to that report. And so some developers would say, well, what have they done with reports in the past? Well, they don't have a history of that, so we don't know. So an example would be, what if the technical requirements that you have in the text amendment scientifically just can't be met? An example would be generators. We know noise is going to be a big issue. And it was a big issue at the JPC, and it's a big issue now. But if the generators, if a place like a data center has to use a generator during emergencies, they don't make generators silent now, right? And everybody knows if you have a generator at your home, typically they make noise. And so if you make a rule that just technically can't be met, then that is a sense putting a moratorium on the development. So we have to look at those more closely. And then the requirements that are typically handled by other parts of government are experts with experience. George is the sole zoning administrator here. In other places, you may have environmental experts, he may have like the staff, they'll have a staff of 10 people that will review specific items. And so what we suggest is for items that are more typically reviewed by state regulatory bodies or federal regulatory bodies, USA County should allow them to issue those permits and do their work. Don't put that on George and the local officials. We believe that the community is protected by those long-standing processes that are usually handled by state and federal regulatory bodies. Okay, let's go now to the specific text amendment. You all should have, and I think does it say Tanner at the top?
Yes, in my bad handwriting.
Okay. So let me go back. This is a good time to address, I think, Mr. Grady's. I don't think we have a dog in this fight necessarily, but his issue with not having a public hearing for development plans already in I-3, I think that can be easily fixed by putting a statement that all data centers, regardless of the zoning, has to come before the Planning Commission for a public hearing for a data center. So we're not opposed to that position at all. It's my understanding that there's not a lot of I-3 available in the county. So that's not really what the public and the people here are most concerned about. I think they're most concerned about what they anticipate will be a large swath of land that's going to be converted from agriculture to I-3 for the data center. But I think we're okay with that. The first red line, so this red line that you all see are my changes, are pretty much the same red line that we had originally presented, so this is not new. The only thing that's new is we had to make a few changes because the JPC has 4 versions. They are on their 4th version, and so the original red line that I submitted on December 9th, it had to be updated based upon the changes that the JPC made. So, let's see, the first one, principal structure. So the change there, we just want the principal structure. For hyperscale data centers, it's going to be a big building, right? So it would look like, in some ways, like an Amazon building on the outside. But on the inside, there's going to be lots of computer equipment and servers. And then the other kind of main part of those data centers are the cooling equipment that are on the outside of the buildings. And so when you all visited, you all can see that. And so all we're asking is to include that mechanical equipment cooling structures, add that as a principal structure. So it's kind of a cleanup, and that also goes to the setbacks. So when we're tying that into the setbacks. And so if you look over on the next page to the setbacks, when we talk about the setbacks, we're saying that it applies to the data center principal structures, and it shouldn't apply to the accessory structures. A data center campus, they may have a guardhouse. They may have some other smaller accessory structures that those aren't the structures that make the noise. Those aren't the things. And so we don't think those should be included. There should be a carve out for those. The height structure, the structure height, already in the code in the ordinance in the code 406.4, there are some exceptions for some carve outs that don't apply to the height. And we're just asking for a clarification that electric poles don't apply to the 75-foot height. We know that data centers use power, and that's one of the reasons we want to be here. The client wants to be here because of EKPC, and so they're going to have power poles that provide power to the plant, to the structures. Buffering and screening. I think the JPC did a good job of that. We talk about, we want some carve-outs, or we need some carve-outs during construction. At the beginning, when we start building, if we get approval and we can start building, there are going to be some things during construction that, for noise and dust, we're going to have to abide by the existing regulations, but construction, it's going to be a lot of dirt moving. And so we need some of that. Some of the measurements, like in that first on page 3, I think it's just, I don't know how we measure air. So, some of that stuff needs to come out. It's just a cleanup. On the landscape buffer, we've asked that clearly where we have entrances, we don't have to have a buffer because we're going to have roadways coming in. The buffer's not going to go. And we need to allow the buffer to meander, to follow the topography. And we ask for a little leeway there. And then finally, if we have existing vegetation and trees, if we can use that as part of the buffer, we don't want to have to take it down and have new plantings. And so we're asking for the language to allow for that. We think that's pretty common sense. Noise, obviously, was a big, it's going to be a big issue for the Planning Commission, for you all to consider. We've looked at a lot of different places on the noise, and we think the noise levels here is certainly acceptable to my client. And we think it's good. We like the noise. We don't think that the noise, we need to carve out for construction activities. Some of that, you're just going to have trucks and bulldozers moving dirt. Typical construction, it's going to be a much bigger project, but there needs to be a carve out for those construction activities. And so, post-closing, pre-closing noise analysis. Here's how it typically works. The client at a zoning hearing has to come forward with a noise study. And the science allows them to say, when the building's built like this, and when we use this type of equipment, this is how much noise it will make. It's science, right? It's math and science. This is how much noise it will make. And at 500 feet, this is how much it will have. And at 750 feet, this is what the sound level will be. And so we will provide that report. As far as post-closing and after that, citizens and George and anybody will be able to challenge those. There is a mechanism, and all by just saying it's violating the ordinance. And they call up George or write George a letter and say, we think this is too loud. I've got my little phone, my little phone app, and I don't know how accurate those are, but people have them, and they're standing at their lot line, and they're saying this is too loud. And they send George a letter, and then George, whoever the owner of the property and the developer of the property is, would then have to say, that's not accurate. Look, we have an expert that shows you what the sound is. And then, so there is a mechanism already built in to your ordinance without anything here. And so we don't need the post-closing study. Citizens are protected just through the normal course. Finally, I talked about it earlier, to generators. I'm not a scientist. I'm not an engineer. My clients, engineers and scientists said that the language where it says generators must adhere to the sound levels during emergency use. My engineers said that can't be. Right? And so what you're saying, well, how do we protect them? Well, first of all, during testing, I don't think there's going to be an issue. I think we can abide by it. Because if you've got 100 generators, they're not going to test them all at the same time. They're going to do those in cycles, 10 or 20 at a time. But during emergency uses, they may have to run all 100. And it may not meet the 50 decibel sound level. But I can say two things. These data centers have to have power. And so they have to have the generators because they can't go down. But they build in redundancies with the power company. So there's going to be redundancies. So that makes it less likely that they would ever be a power outage to the data center. And even if they do have, like my client has said, at other locations, the total running time of emergencies for the year might be 4 days for the entire year. And that's not 4 days at a time, it's 6 hours here, 6 hours there, but for a total of 4 days in the year. So we're talking very little. And if the data center's power's out, the neighbor's power is going to be out likely too, right? And so those neighbors are probably running generators. And if they have a generator running at their own home, they're not going to hear generators 1,000 feet away. So that's just from a practical point. Let's see, design standards. Section I. I think what we said is we'll adhere to all the visual screening and noise requirements, but the project must have the ability to control how they design the layout. So we remove that section about that the structures have to be to the side and the rear of the principal structure. Well, we don't have the final layout yet, but when we lay out the buildings, we have to have the ability to put those side yards and those air conditioners or those cooling mechanisms in the most efficient place. And so having that decided ahead of time makes it difficult for developers. Let's see. The development plan. So maybe, is that L, section L? Mm-hmm. Jack, will you come up here? Do you mind coming up here? Jack Ammerman from Stantec, who's part of our team. He's the engineer. And so the reason we changed, it looks like we changed a lot in the development plan. But if you go down through there and see all of the listings, it just looks, it's red and blue, but there's a lot of overlap of the same thing. And And so this is what we're proposing, I think, is what's common in everywhere I've been, Jack's all over the country. And so what we're really trying to get at is, at the site plan and at the development phase, you don't typically have full construction drawings. You have kind of preliminary drawings. You don't go into detail about exactly where all the electric lines run and the you know, like you've seen that, right? It almost looks like a blue. It's the difference between, like, when you first look at like a book for building a home and you just look at the outline plan of what the home will look like, and then you hire an architect, and then at the end though they get into the construction drawings. And so that's what we're trying to do here, is just saying, hey, we'll provide everything that the Joint Planning Commission needs for a site plan, but we shouldn't have to give you full construction drawings.
Yeah, if I may, Jack Ammerman with Stantec. I'm a licensed civil engineer in the state of Kentucky as well as many other states. I lead and manage a team currently around 80 individuals plus others that work on these types of projects all over North America. I've lived in this world for the last 5 years. Started my career doing commercial retail where we were doing McDonald's, right? So projects of this size and scale, it takes a massive amount to get to the level of detail that you're looking at in this current ordinance. And so the intent of a planning rezone is to show you that the engineering is feasible, that we can meet the planning requirements, the setbacks, the area, the lots. The engineering will be reviewed at the time of the permit by those correct authorities. So a simplified and 30% or preliminary submittal just shows, yes, we can do the engineering and we'll get there, and that'll be reviewed later. And that is common in my entire career, whether it's a McDonald's, an apartment building, or a large-scale project like this. Thank you.
Thanks, Sharon. I went a lot longer than I thought. On the utility plan, again, it looks like we've taken a lot of out. But I think ultimately what we're proposing is exactly what everybody wants. We're saying we will, at the zoning map amendment, we will give you a letter from the local utilities to say, a will serve letter, right? That we have the capacity, we'll go and we'll have to present a letter to the Planning Commission to say, hey, if they build this data center, we have enough capacity on the grid to be able to supply power, and we'll do that for water and electric. And so, really, I think we've simplified it by saying that's what we'll provide. And we don't have to go through all that. We just have to provide you a letter, and your utilities are going to tell us that. We're not going to. They're going to have to tell it. The last two, kind of, and you can see the environmental impact. We're going to have to do this. Any permits, we're going to have to get all state and federal water, environmental permits. But this goes to what we talked about, George being a man of one. Do you really want him? I don't think he's an environmental expert. And in fact, at some of the JPC meetings, he said, oh, they provide the report, it's kind of like a check box. I check it off. So he's not necessarily even reviewing that. I mean, I know he's reviewing it, but he doesn't have, I don't think he's a water engineer or water quality expert, and so we're going to have to do that, and you can even put it in the text amendment. I mean, we're going to have to get that no matter what, and you can make that a requirement that we show it, but just know that that's all, you're already covered and the citizens are protected. Community impact. Somebody brought up, the judge has been working with this developer for a long time. The state of Kentucky and Frankfurt have been working with this developer. There are going to be community development agreements. That's who should handle them. George and the zoning and the JPC, that's not really their bailiwick, right? That's not what the community impact and economic development is not That's not where their expert lies. The economic development people should handle the community aspects. And that's the language that I put. The complaint procedures. Decommissioning plan. Again, I've taken out most of it because this is not like a solar project. A decommissioning plan here, these are buildings. These are buildings, and first of all, we don't think they're going to go dark. We don't anticipate that. And so we don't think it's appropriate for us to have a decommissioning plan when they're not in anything except solar, which can go back to farmland. These are buildings. And then the complaint procedure, George, just through the normal complaint procedure, people can call in like I talked about with the noise. They don't need a special complaint procedure. Mr. Grady talked about the $500 and they were opposed to that. And so by putting in this new complaint procedure, it's really, it's unneeded. And so we would be okay with removing it, but if it stays in, we think it should be handled through by George.
Sorry. Sort of a rude way to end it. I apologize.
Well done. Well done. Thank you.
And Mr. Grady reserved 4 minutes. All right.
Yes, sir.
Judge Executive, the document is the Urban Land Institute Local Guidelines for Data Center Development.
Thank you, sir.
Say again?
Yep. So, I thank you.
Okay. I did hear Tanner say, this is a great start. And I will agree with that. I do think this is a good start. I heard him say that he thinks adding public hearings is okay, and I'm glad to hear that. I am concerned about his request to remove the environmental impact study, the community impact analysis, and from the development plan process. And I'm concerned about Jack's suggestion about these details will come later. As a planning and zoning lawyer, I have a lot of experience that at the zone change stage, we get a zone request and the bare bones document that is the outline of the building, but I want to know if the stormwater plan is going to be adequate. And I'm told, well, you don't get that now. That comes later. That comes when we get our building permit. This is a zone change, and you only get what we put in front of you. And the zone change is the only time the planning commission has the ability to say yes or no. After that, it's going to be built. So I am concerned if the critical details about environmental impacts and community agreements and other utility compliance features are postponed past the public hearing and past the zone change, then the public has no way to know and comment on what's going to happen. In my text to the Planning Commission, it's not in the letter I gave you today. I suggest language that requires when a data center applies, the application includes a fee appropriate to hire help for George. So he's not doing this as a one-man shop. He can retain the expertise he needs from the fee the applicant pays in order to hire the expertise at the local level. And so those are suggestions that are in my text that are reasons I believe this matter needs to be sent back to the Planning Commission for more work. I heard the phrase, "we like the noise." I don't think he meant to say that. But I would urge a more restrictive noise requirement as set forth in my text. I do want to explain two things. This is one of the documents that I relied upon, the Prince George study, the 500-page document. It's true that they probably do have a large staff and did a lot of work, and it's evident in those 500 pages. But the point is, those 500 pages are on the web, and I tried to put them in the record in this case, and I've given you some pages out of them to help you access that research. So we have the benefit in Mason County from the work other people have done. Finally, you all have scheduled this for next week for second reading. I think that you may want to consider postponing next week to allow you sufficient time to think about what you have heard and what kind of recommendations you want to make. I would urge that this is not ready for final action. I hope that you've heard enough today to agree this needs more work. But I do think the need to come back next week for a second reading is probably quicker than appropriate, and I would urge you to take the time you need to think about what you've heard this morning. Again, thank you for the opportunity to be here. I agree with Tanner. Mason County is an amazing place, and I want to help you keep it as an amazing place. Thank you.
Thank you, sir. Okay. Thanks, sir.
Your Honor, if I could do some explanation prior to doing a first reading and review.
Yes, sir, please.
First of all, somebody has to draft ordinances. The Planning Commission, and I agree with everybody that's echoed, for volunteers have got a ton of work, thought, and thoughtfulness into this. But ultimately, George, the task of drafting regulations falls to George. And with regard to ordinance of the Mason Fiscal Court, it falls to me. So this is, and I'll take blame, because I think that generally speaking, this ordinance probably doesn't make either side entirely happy. This ordinance is developed and it's not available to the public. It will be available today to the public. And the reason it's not available is because it was completed last night. I worked Saturday and Sunday with the judge's input on various matters. So this would represent, Your Honor, my recommendations and your recommendations for an ordinance which would largely adopt but modify the recommended regulations of the Planning Commission. Going forward from here, I talked to George yesterday, and Mr. Larger probably would pull Mr. Clark in, who's got so much time and effort with working with the Planning Commission, and Robin and Rice in my office, who y'all know does a good job with zoning issues, and we'll continue to review and work on this. In addition, y'all should contact me directly to make suggestions, because coming up with a draft, we need to know what you think. As we had said, we've got the judge's input at this point, but need your input as well. A couple of things I would mention that I've heard in this process. First of all, I thank Mr. Grady, I've known for a good time, being gentlemanly adverse to one another over the years. But think a lot of Mr. Grady. He did a good job. And Tanner Nichols, thank you for being here, and thank you for the job and the professionalism that you've done in this, or handled in this. A couple things, and these are comments, and they're not my pontificating or opinion. It's a sort of a legal basis. I want to say that in all this evidence, one thing that comes to me is that there has been lots of evidence and testimony regarding what I consider to be national electric policy, and the fellows at East Kentucky could could school me in that because I know very little about it. But the Kentucky PSC sets rates for water and electric, and the federal government manages the grid and where the need is and how to supply people's need for electric. And that's outside planning, I mean, it's outside planning commission purview, really, and it's outside your purview to handle those matters. I would say with regard to water, that in general, the home rule statute for counties, you do have responsibility for development, water and state, expanding and stability and having potable drinking water to your homes and businesses. So, water is different than electric, but this is not a referendum on or for you to regulate national energy policy. Along the same line, I was watching a morning show this morning, and they had all kinds of scary AI stories going on. And I, being older and not very technologically savvy, AI scares me, although I used AI, a Westlaw version, to prepare for this. So this is not a referendum on technology. The market and the federal government and the legislature regulate that. It's something that's sort of beyond what county can do. So, county has to stick to its lanes, and our lanes, I mentioned water, but are, providing for economic development, providing tax base, providing jobs and stable population, while balancing all of that against homeowners, property owners, and citizens' rights to protection. And that's what zoning is all about. So I just suggest we focus on that. The other thing I would mention, and it's mentioned in both the attorney's responses or statements here today, and frankly, I appreciate those pre-submissions to me very much, because having those permitted us to come up with this draft. So thank you for that. When we get through this, and so I don't spend as much time going through a draft, getting into such complex matters, but the federal government has supremacy in air, water, waste, and the Corps of Engineers with respect to wetlands, streams, crossings, those sort of things. The federal government delegates those authorities for water, air, and waste to the state of Kentucky Cabinet for Environmental Protection and Natural Resources. So there will be lots of permitting and lots of regulations applicable to this project. I've attempted in this draft to give deference to federal regulators. We can't send Sheriff Swolsky out to do air or water monitoring. However, if there is a KPDS water discharge permit for this facility, then the state of Kentucky is going to be doing that. So we want to defer to state regulators and make compliance with permitting and regulations, incorporate that. So that's some of the basis for this. And with that, Your Honor, I'm going to go ahead and read this ordinance by summary and then go through the regulations.
Please.
You are required in zoning matters to adopt findings of fact, conclusions of law, and in this case, regulations for data center. This is by summary 2601, and I'm only going to read the heading of it. An ordinance adopting and affirming the findings of fact of the Mason County Joint Planning Commission pertaining to the siting and regulation of data centers in Mason County, Kentucky. Adopting the recommendation for the amendment of Mason Fiscal Court Ordinance Number 0207 with modifications to the proposed amendments. Establishing a land classification for data centers and amending the land use charts and republishing Ordinance Number 02-07 to incorporate such amendments. In general, there's a bunch of whereases that recites the history of this from your adoption of 2518, requesting the Planning Commission undertake this. The public hearings, the meetings of the Planning Commission are set forth, discusses and recites and says that you share in the goals of the Planning Commission. The Planning Commission recited that their purpose was in the siting, development, construction of potential data center in a predictable manner that promotes and protects the safety, health, and welfare of the community, and balances the benefits of economic development, increased tax revenue for local government, and the school system, and job creation with protection of agriculture, existing residential uses, existing built environment, and historic, natural, or other sensitive areas. So this adopts that as your purpose here in this. It recognizes, and we probably will change the whereases to further incorporate some of what Mr. Nichols and Mr. Grady put on in their argument today. It adopts the findings of fact as they are, but makes different conclusions on a couple of matters, or different recommendations. And then this would also amend, it would adopt the regulations, which I'm going to review, and it would adopt a amendment of the land use classification charts to make data centers allowable use in the I-3 rural industrial zones. And reviewing those actual, and let me mention this. I said available. I'll make sure that I run copies for council, and so you can take those with you. The public, George, can we get this? What time period could we publish this on your site?
He's gone.
Oh, okay. Well,
You can have it up there this afternoon.
okay. And I asked Sherry, and she said by close of business today, at some point late afternoon, we'll have copies for anybody. If you leave an email list, we probably can email out copies this afternoon or shortly after the meeting. But there's a number of adoptions of what Mr. Nichols reviewed and provided in his red line, particularly in the early parts of this, including, for instance, in the definitions, data center principal structure includes the cooling tower. We adopted that. We included, it was not in it before, but the definition of rural industrial, which is to recognize existing manufacturing industries in rural areas, but also to encourage recruitment of new manufacturing industries in those areas. That's already a definition. I just included the definition. Again, the permitted use is only changes that data centers are permitted in the I-3. And that's 417.2. Obviously, map amendments, and that I would predict that's where more information about this project will come out, more information about economic benefits of the project in the map amendment. So this only creates I-3, and the I-3 land's pretty limited, and my recollection is that Carmoose or East Kentucky and International Paper owns all the I-3 land in Mason County, or nearly all of it. So it would require a map amendment, which would be a separate proceeding. The setbacks at 417.3, after considering public request at the meetings, reading Mr. Grady's letter, Judge McNeil suggested that we change the setbacks so it would remain 500 feet, but it would be 750-foot setback from in any sensitive uses. In other words, and I don't think most of the sensitive uses, which are defined as schools, preschools, daycares, I don't think most of those apply, but existing residents, the setbacks would be 750 feet, not the 500 feet recommended. Structure height, Mr. Nichols indicated, we have added electric poles are exempted. Similar structures as that, which would not be limited. If East Kentucky's putting up, East Kentucky's not regulated by zoning. If anything East Kentucky does is not regulated by zoning, PSC preempts that. But if the applicant or the prospective data center were to put up poles greater than 75 feet, that would be exempted as part of utility. There's limitations as to having hardscape, and this recognizes that utility structures may require some hardscape, concrete blacktop, so it permits that. Just adds the word hardscape for utilities to that prohibition. In the buffering and screening, again, those words were cut down. So we're regulating dust, smoke, and exhaust, but the words like air and humidity were removed. The existing use of existing vegetation makes perfectly good sense to me. I never thought of that, but you don't want to bulldoze out long-standing trees and native grasses that can be incorporated in to put a modern buffering vegetation in, so that was added.
Which you already have.
Yeah, it's already added. The noise limitations remain exactly like they are. Construction activities are excluded, however, which is typical. I mean, you couldn't keep the noise requirements at the landfill that you operate. We are regulated by state government on dust at our landfill, and you run a water truck full time. So I think it's consistent with that for that or any other construction site. There'll be regulation of it, but these noise ordinances won't apply. I did leave in the sections. I didn't agree with Mr. Nichols and the pre and post noise analysis we have left in here. Basically, what we've tried to do is adopt the practical portions of this where their definitions may make more sense because they have a specialty here that the Planning Commission didn't. But leave in any public protections. In other words, not accept the prospect recommendation and any public protections be. So we've hunkered down on the public protections, but cleaned up language where it may be more practical. We've added the language with regard to generators. The generators only can be run for testing, and they can only be run in emergency outing and outages. And the outages, it will be the newest electrical system in our area, so I think you'd expect outages to be less than what I get in Mays Lake.
Yeah.
It's close by to East Kentucky. It'll all be new, so it's not like a subdivision that has lines run all throughout the county and transformers to them. But I've added language that wasn't in there that said, the generators can't be used for economic reasons or convenience. That it has to be an actual emergency. And in response to Mr. Nichols and Jack Ammerman saying we can't comply, if there's a complete outage, if there's an emergency, we can't comply. I wanted to add something so that there's just not sort of a carte blanche, do what you want with your generators when there's times of emergency. So I've added this language. Even during the testing at the intervals provided above and in emergencies during power outages interruptions, generators must be designed, operated, buffered, and or screened in a fashion so that the sound levels do not deprive owners and residents in sensitive use areas of the enjoyment of their property and should not allowed to constitute a private or public nuisance in such regard, provided that the nature and duration of any power outage or interruption may be considered in balancing the need for emergency generator use versus the rights of others to enjoyment of their property within the sensitive use areas. And I think that's trying to do exactly what Mr. Nichols said, is if the whole area's out, which means that not only is East Kentucky down, but other power sources that could be used, the redundancies are down, that likely I think there's going to be less objection about generators if everybody in the county is out of power.
100%.
We want to ensure that while everybody else has power, that they're not running generators for some sort of convenience. So that's what these do, and they adopt nuisance rules so that you could have a weighing of, gosh, this is a real, there's a massive ice storm, there's a tornado, these are real emergencies versus something that could be convenient. So that's the language we've adopted, and everybody can review that and comment. We did remove the design standard that it said the buildings had to be, all accessory uses had to be at the rear and side, and there's going to be a site development plan approved and have to abide by setbacks. And again, we shouldn't be designing this thing. I don't know what that necessarily accomplished. So that was removed. Otherwise, the design standards stayed as they are. We did take out, there's a design standard that says minimize glare and reflection on adjacent properties and roadways, but we took out, it required textured glass, anti-glare coatings. Those are things that the developer should determine how to reduce glare, not as put in specific design. So that language was removed, but they still have to minimize glare and reflection. it is required by the JPC's ordinance that everything be housed in a metered, electronically grounded structure with a fire rating designed to resist an internal electrical fire of at least 30 minutes. And it's got to have fire containment, baffles, etc. We have added that only the structures containing the data center equipment. In other words, if you have a tool shed, or you have an office, or you have a guard shack, they're not going to have to be these sort of buildings. It's going to be where the equipment is. And again, these are just practical changes. I think they just make it possible to comply with this while keeping the protections. The development plan, the development plan in our planning ordinance, and it typically would have been used for subdivisions, townhome developments, that sort of things, residential, not something of this scale. But it does not provide for public hearing. Our existing ordinance that we're putting this in does not require a public hearing. This does make it clear that the whole JPC and not the zoning administrator needs to prepare. Mr. Grady says there should be public input. Well, there can be public input. It's just not required a full-blown hearing like what is required for this text amendment or the map amendment, which would require full-blown hearing. So there can be input, but it's not required to open up a set public hearing process. The change I've made is that Planning Commission has 60 days to approve with conditions, or disapprove the development plan, and then that determination can be reviewed by the fiscal court. And if they fail to do so in 60 days, the fiscal court can make that decision de novo. In other words, not relying on the underlying recommendations. So it gives a fiscal court oversight of the development plan approval. Mr. Ammerman and Mr. Nichols, I did agree with them that their development plan requirements makes more sense. So we have adopted their development plan requirements. As you review these, you're going to find that it doesn't leave anything out. It might just be better organized. It requires boundary lines, square footages, title information, descriptions of topography, preliminary rough grading proposals, site plan and develop parking, service roads, vehicle entrances, paved roads, proposed trash collection. It requires all the utility plans for electric, water, sewage, all waste. It has preliminary grading and drainage plans, which would address a good bit of these, including erosion control. And then it has a landscape plan, which is how they will propose all their buffer and make sure it complies. Going on to utility plan, we did accept the will serve letters. In other words, utilities, water utility, electric utility, will determine if they have capacity. We left in from the Planning Commission the provisions that say those letters should say, the electric utility should say, providing this service will not cause voltage fluctuations or affect service of our other customers. In other words, not only do they provide a will serve letter, but they've got to say it's not going to be causing problems to other people. And the water utility would be the same way. The letter would say not only that we can serve it, but it's not going to impact needs of others. The environmental impact assessment, I've discussed that in broad view, but basically says that if you have a water permit, you describe that you have a water permit, what the requirements of the water permit are, and a statement that you'll comply with it. If you have an air permit, you'll do the same thing, and you'll list what permits, what they covered, and have an assurance that you'll comply with it. If you don't have those permits, then you have to have a assessment of impacts for air and best management practices you'll adopt. You'll have to have water pollution impacts. You'll have to have discuss public nuisances, truck traffic and the like, and an erosion control plan if you don't have those permitted by a state or federal agency. Community impact analysis is pretty similar to what the Planning Commission included. We did take out all economic basis. In other words, when JPC's looking at this after map amendment, they should have already considered economic impact in the weighing of increased tax, increased jobs, increased population versus protection of farmland, protection of citizens' homes, et cetera. And that economic benefit should have already been taken care of. So I don't think it's appropriate to be part of a community impact plan. And, you know, this focuses on emergency services and fire protection, disposal of materials, looking at nuisance type matters,
Emergency plans with Tony.
emergency plans, yes, all that type of thing. The community income, dust control plan. So most of the protections are there. It just doesn't require to do a economic justification when that's already been done. And then the decommissioning plan, and George and I and Michael Clark discussed this when it was going through the Plan Commission. You know, I have some concerns about a decommissioning plan, but the decommissioning plan adopted looked at our experience with wind and solar energy, both of which take an agricultural use, put something there that has zero value when it leaves, and if they went away, you would have a field that can't be farmed, items there that may or may not be hazardous waste, contour changes. So there are real concerns about, in those areas, with having a decommissioning plan that involved bonds. Here we've adopted a decommissioning plan which is similar to what we've done in solid waste areas in our nuisance abatement ordinance. I think there's about 3 or 4 ordinances where we've done this. But basically, decommissioning is required if the site is abandoned or closed of any equipment or other personal property on the property. They're to provide a decommissioning plan, which is, you know, what's the likely way, what's the life expectancy, what happens at end of life expectancy of equipment, does it get landfilled, sold, recycled? So there would be something of a statement that we could follow for a decommissioning plan. But if this project was abandoned, the fiscal court could give 120 days notice that they need to remove all equipment. If they don't do it, the fiscal court could, but not required to, enter the property, undertake decommissioning itself, and file a lien against the property sue them for damages and the cost if they want to, or just file a lien against the property, which we would collected to stand good for the decommissioning costs. So, you know, basically you're not going to have a bond that's because you're going to have a very valuable piece of properties with very valuable improvements. The properties are going to be the bond, and the lien is going to be the way to secure it, as opposed to having a moving target to figure out what this bond should be and how do they come up with it, and is their bond just a promise from a developer, or is their bond some sort of corporate surety who may or may not be there 30 years from now. So we see this as this property should stand good for the decommissioning, so we've created a lien procedure. The complaint, finally, really final, the complaint procedure is just simplified. The Planning Commission came up with a requirement that the data center owner would log all their own complaints and keep track of their own complaints, and then attempt to resolve, and then if they weren't resolved, they would come to the zoning official. We basically just cut that out, and if somebody has a complaint, they go to George Larger for it, and if it's not resolved after 60 days, we left this in there from the Planning Commission, that it goes to arbitration. You know, arbitration is binding, unlike mediations, which we use a lot, and I would differ, or just sort of say my opinion, as opposed to Mr. Grady's, that it's a $500 penalty. If somebody wanted to file a circuit court action for nuisance against their data center neighbor, the filing fees are nearly $500, not imagining what an attorney costs. This gives, at a pretty reasonable rate, you know, you expect an arbitrator to be a $5,000 or $6,000 or $7,000 expense. It has the data center bearing that. So this $500 deposit is I guess they intended to do away with frivolous complaints, but would be a whole lot cheaper than filing suit. So we've left that in there. And that is ordinance number 26-1 with the Exhibit A, which are the regulations. by summary.
Commissioners? Discussion, questions?
As I said, y'all got version which is complete as of late yesterday afternoon. We just handed you. It wasn't ready when I saw Commissioner McKay picking up the notebook yesterday. It wasn't ready, or I would have had it to you then till later yesterday. And the public will get it to you later. I'm sorry, Peggy.
I'm going to request that we move this another 2 weeks to give all of us time to look at all this information. This is the lost stuff you've given us today. And this really needs to be looked at good. So I'm asking for a 2-week breather. I'm not against data centers. I don't want you to think that, but I
Sure.
just think this is something that needs to be looked at very, very carefully.
Any other questions on what John?
And the statute would require no more than 21 from you.
Correct, yeah. Look, I don't think, we have to remember as a community, this is a process. As I've stated on numerous occasions, the text amendment somebody used the words earlier, guardrails for any and all of this specific use coming into Mason County into perpetuity. I know our friends probably are not very happy with some of these changes, but I like and am attracted to differentiating out sensitive use areas. And if you can't reasonably move into an area 750 feet out without offending your neighbor, we would have issues. Outside of that, the majority of this is exactly what the JPC passed.
Judge, got a question.
Sure.
Let's say next week we meet and discuss this. Is it possible that after a week of studying, it's not like we haven't been keeping up with this process over the last several months. Is it possible that we could discuss this and maybe suggest maybe a different change next week?
Yes, sir. Yes, sir.
Okay.
I'd ask, the only thing I'd ask is that you, if you have questions or suggest changes, tell me so that we can adopt a draft to be considered and voted on of your change. First reading does not require a vote, and wouldn't ask you to vote on something you haven't read, obviously.
Correct.
So you would have a vote to adopt it, but if Commissioner McKay had a change requested, I'll get the language ready, and then you can have a vote of the whole fiscal court to determine whether you wanted to incorporate that or not incorporate, and then we would have some record of what you've adopted and what the final language is. I don't want to have a bunch of changes to be.
I understand.
Well, it leaves me too much discretion. I want to be directed what to do when you take your vote, not guessing what you wanted to do.
Thank you for that input. Thank you.
And, it's an ongoing discussion. I think, if an issue arises even tomorrow, go ahead, I think, and bring it up and we'll start talking about it.
The other thing I'd say, Judge, to the commissioners and to you, if you want to vote to increase the setbacks to 1,000 feet or reduce them to 250, don't come to me, because that's a policy matter.
Yeah.
You just make that motion in the court. But if it's something that we need to craft language or correct language, that's only my role. If it changes the tenor of the thing or some policy, that's up to y'all, not me. But I'll be your draftsman. If you have an idea, I'll come up with a draft of what you want to do.
Well, I'm asking for 2 weeks to look at all of this and reevaluate it, that's all. And
Well, Commissioner, I don't think there's.
Could you-
unless I'm
nobody
wrong,
agrees that we need a little more time.
Well, I would like, Judge, would you explain the process moving forward after a second reading is held, whenever that is?
Sure. So after following up Tuesday's second reading, at some point following that, this ordinance would be codified within Mason County. interest, economic interest, looking in our area would either state, hey, yeah, I think we can make that work, or they would go on and bolster another community's opportunities and abilities for people and young people to stay there. At that point, they would submit their map amendment back to the JPC for review. The JPC would have 60 days, to approve, deny, go forward. So, does that answer your question?
Mhm.
Sure.
So what would it matter if you delayed it another week?
Because we've been working on this for 2
Give me
years.
time to look at all of this, that's all I'm asking for.
Sure.
I mean, this is a lot of information,
Sure.
a lot of requests, and I'm not against data centers, I'm not saying that at all. I think data centers are a good thing
Okay.
in the right place, but I think we need time to look at all these regulations that the
Yep.
lawyers have talked about today and that the joint planning has talked about, and just to look at it and really look at it deep.
Sure. I
That's all I'm
disagree.
asking.
I know. I disagree.
Okay, well, that's
Okay.
a part of being in America, to be able to
I
disagree.
Amen.
That's the good thing about our country.
So do we need a motion to approve our first reading?
I know, I think just to let the record reflect, we've had a reading by summary and an explanation of the attachment A, which was exhibits of 2601. And we will work on, I emailed this to George, I'll make sure he puts it up today. We'll get with Sherry and see, she'll start producing some of these for this afternoon. And I guess I could, if somebody wants to make a sign-up list of emails,
Right here, it's on the
if
podium.
anybody wants to put emails, I'll email them out when I get back to work.
Any additional questions? Commissioners, do you all have any thoughts on Commissioner's Frame's thoughts on postponing next Tuesday?
I'm okay with a week. I'm okay with a week.
Okay.
It gives me enough time to look at this.
Good.
I think we've kicked this down the can. Most of the comments I've heard is it's just time to deal with it.
Yep.
Let's just throw it on the wall and see what sticks.
Commissioners, it brings us up to communications. Any three of you have any communications from the court? First, I would like to thank my good friend Hank Gaddy for traveling up. Outstanding presentation. Mr. Nichols and Ammerman, thank you very much for your presentation. I think the commissioners join me in our appreciation for the Joint Planning Commission, their efforts, and last but not least, I greatly appreciate County Attorney John Estel for his efforts moving forward. Commissioners, I want to remind you, Saturday, February 28th, the benefit for Melissa and Brandon Hamilton, lost everything in a fire, will be out in Germantown. There's an auction benefit trying to raise money in their support. Also, next Wednesday, the 25th, the Dover Volunteer Fire Spaghetti Dinner. And I'd also highlight our animal shelter for the great job they did last night in tracking down my good friend Debbie Beelan's dog, Max, in the Jersey Ridge. And I think they have rescued Max back to the good folks of Beelan's. So, without any further ado, I will entertain a motion to adjourn.
So moved.
Second.
Got a motion, got a second. Any additional discussion? Roll call, Madam Clerk.
Commissioner McKay?
Yes, ma'am.
Commissioner O'Hearn?
Yes, ma'am.
Commissioner Frame?
Yes, ma'am.
Judge McNeil?
Yes, ma'am.